line would rise, then you would have a line that was closer into your property. If the beach line would recede, then your property ownership would again always touch that water. But with the establishment of an erosion control line, it fixed that boundary. It was no longer fluid, it was no longer flexible. And it allowed the state to then go in and move sand from some locations to another to prevent beach erosion. Well, what these owners argued in this Stop the Beach renourishment case was that they had lost their direct connection with water. And that was one of littoral rights. It was one of the foundations of being an owner abutting water, was you always had the right to access the property abutting the water. Now they had lost that direct contact with the establishment of an erosion control line. So we deal with a lot of unique terms to littoral property owners, but the owners had lost what they considered the value of what's called accretion, which is where land is added to your property as a result of the water, or something called reliction, which is where you have an increase in land due to the withdrawal of the water. So you can have water add land to your property, such as pushing sand up on it, and you can have the water line recede with reliction, in which case you would have additional ownership. The Florida Supreme Court decided that the public had a right to restore the shoreline lost by an evulsive event. And an evulsive event would be an event such as a hurricane, which had a dramatic impact and a change on the shoreline. And they held that the Beach and Shore Preservation Act authorized the state to restore those storm-damaged properties, and that Florida common law did not allow the right to have a property's contact with the water remain intact, and that contact was ancillary to the right of access. So what the court did, in essence, was they said, okay, you don't own the property abutting the water anymore, but you can still access the water, and that's just as good. And the owner said, no, we've lost the inherent right, littoral right that we had under Florida common law. The court went on to say that the Beach and Shore Preservation Act was facially constitutional and did not deprive the owners of their littoral rights. The owners in this case have argued essentially that what the Supreme Court did was they redefined common law, redefined littoral rights, which are the rights to access the water of our abutting property. There are three questions that are now before the United States Supreme Court. The first, and these are all argued by the property owner. The first arguing that what has happened here is, with this decision from the Florida Supreme Court, is you now have a judicial taking of property because they've redefined the common law rights that we've always had for littoral access. They've also argued, secondly, that you have a violation of due process because this legislative scheme eliminated the rights that we had and gave us statutory rights, which are in violation of the inherent rights that we have under the common law. So we were denied due process. And then finally, the owners are arguing that the approval of that legislative scheme allows the executive branch, meaning the individual departments, to establish that erosion control line to unilaterally modify our property boundary without any kind of hearing or decision of any nature. So this case is, in some ways, kind of mirrors the citrus grove cases that we had years ago, where you had the word concern about citrus canker and taking of trees in people's yards, where the department found that there might be canker. Well, they would just destroy all trees within a certain distance from the cankerous tree. And the Supreme Court in those cases did find a taking occurred, and here they have not. So it'll be interesting to see what the United States Supreme Court does with this decision. This will be one to watch, and hopefully one that will be decided before next year. But anytime the United States Supreme Court accepts jurisdiction for a property rights case, it's going to be a big deal. The last notable case that we had come out of the United States Supreme Court was Lingle versus Chevron, which you'll probably hear about later today. But that case and a couple of other cases, Dolman and Nolan, you'll hear about some more, all touched upon what constitutes an inverse taking of property, which this case does as well. The next case we have to talk about is Kirkland versus City of Lakeland. This is a decision that dealt with the right of the City of Lakeland to take property under quick take proceedings. For those who don't know, in Florida we have two procedures where property is acquired. One is the quick take proceeding, essentially where the condemnor acquires title before final payment is made to the property owner. Hence, it's a quick quick taking. They are able to acquire title before full adjudication of the award. The other procedure in Florida is called a slow taking, and that's where you have a determination of what the final award is first, and then the condemnor acquires the title after that. In this case, the City of Lakeland had initiated a quick take proceeding against the Kirklands to acquire title of property outside of the city limits. It was within the county limits, but outside of the city limits. And it was to acquire title for a road widening of a section of road that was managed by the county. The owners argued, well, look, this is really just a pretext to trying to annex our property into the city. There was an attempt to annex our property into the city a few years ago, and it failed, and this is really just a pretext on the city's part to do that. And we have a rich, the owners argued that they had a rich history in that area and founded the property and wanted to prevent taking from occurring, so they used every effort they could to prevent that from happening. The court made its decision based on statutory authority, finding that a municipality was authorized to take property outside of its limits under the statute giving a municipality or city the authority to condemn. And it didn't didn't restrict the city to taking property only within its limits. The decision turned on a critical fact, though, and that was an interlocal agreement between the city and the county. The county and the city were basically on the same page for this road project that was being taken by the city. The court went on to find that the statute dealing with maintenance of roads, which is 335, doesn't regulate the municipality's power of eminent domain, even if it required the county to maintain the road. And the appellate court affirmed the trial court's taking in that case, finding necessity for the taking. Another quick take case that we're dealing with is Gil Erickson Properties versus Pompano Beach Community Redevelopment Agency. In this case, this is a good lesson in not sitting on your rights too long. About a year after an order of taking occurred, where the trial court decided that the condemnor could take title to the property that it was seeking for the road project. A year after that taking occurred, for the public project. A year after that taking occurred, the owner argued that the taking should be set aside, arguing essentially that the lawyers who were working for me then didn't have authority to stipulate to the order of taking. They exceeded their authority and there was fraud. The owner had hired a new set of lawyers who was trying to make this argument to set aside the taking. They also argued that the condemnor did not have jurisdiction because the resolution giving it authority was improper. What happened, though, was the owner had withdrawn the good faith estimate of value that was deposited in the court registry to secure that taking. The appellate court essentially found that after you withdraw those funds from the court registry, you waive any argument that your lawyer did not have authority to stipulate to the order of taking, and you also waive any argument that the trial court didn't have subject matter jurisdiction because of an alleged defect in the resolution. So withdrawing the money and waiting a year, you're not going to be able to make any kind of claim to set aside the order of taking based on Gil Erickson. Another interesting case is Levy County versus Diamond. This is a situation where the owners had sued in inverse condemnation 3 different entities. They sued Levy County, they sued the trustees of the Internal Improvement Fund, and they sued the Department of Environmental Protection, all for inverse condemnation. They filed suit in Leon County, which is in Tallahassee, where the Department of Environmental Protection and the trustees are all located. Levy County sought to transfer venue, which is where the case was going to be argued, from Leon County back to Levy County, and Levy County obtained a waiver from both the trustees of the Internal Improvement Fund and the Department of Environmental Protection. The trial court denied Levy County's motion, and the appellate court reversed and said that home venue privilege can be waived, and it was waived here by the trustees and by the DEP, and that the trial court erred in denying the county's motion to transfer venue to where the property was located and where the documents and nearly all the witnesses were located. Another unique eminent domain case that came out this year is Drake versus Walton County. This is the second of the 2 Hurricane Opal cases that we have, the first one being the Stop the Beach renourishment case. In the Hurricane Opal case, you had a decision made by the First District Court of Appeal that a taking occurs as a matter of law decision for an appellate court to make. Chronologically, in 1992, the owner bought this property. When the owner bought the property in 1992, it was in good condition.